Happy Friday. Welcome to another privacy chat where for about 30 minutes or so, unless we get carried away, I will share some exciting things that are going on in the thrilling land of privacy and AI. And I have somebody to keep me company actually to provide some thoughtful advice and input to you, our friends. I have Sheri Porath Rockwell, who's a senior member of the legal team at Sidley. She's based in their LA office. And although she works all over the country, maybe all over the world sometimes, she is one of the real people I look to for deep insights on what's actually happening in California and all things related to cookie wiretapping legislation. And the reason I like that topic, well, I don't love the topic because I think people understand that this is this weird thing that has led to cookie banners. And the one thing we all thought was a bad outcome of the GDPR e-privacy interaction in Europe that they would like to fix is the annoyance of cookie banners, which nobody really truly thinks has solved a privacy problem or been thrilling to consumers. And it's ugly. And suddenly we have them in the US. And one of the big drivers is companies somehow trying to address this legal risk with cookie banners. So super ugly. But the reason I am particularly interested in this issue is that many years ago, when I was the chief privacy officer at DoubleClick, which I say way too much on this show, but we were hit with these wiretapping lawsuits, and they were absurd, and the courts threw them out. And suddenly, 20 plus years later, they're back. Sheri, briefly, why are they back? And what is the argument for why these make no sense? And obviously, I don't want to talk about the business argument. People are being sued, they're paying class actions, the settlements are going away, and it seems like a big, nuisance that is leading to just sort of, payments one after another. And so, of course, businesses don't like that. Okay, fine. That's maybe a legitimate reason to look at it. But there's a much more logical privacy argument, for what we all, regulators, California Privacy Agency advocates, want and think is the proper direction for better rules around ad tech. And it's not necessarily cookie banners, right? It is global opt-outs. It's the privacy state laws, hopefully soon federal laws. So give us a little bit of a...
Yeah, no, I think you're exactly right. I think the argument is that the California legislature has spent a long time first passing and in subsequent legislative sessions refining the California Consumer Privacy Act, where, like all other U.S. states, we agreed on an opt-out regime, and coupled increasingly with data minimization, and coupled increasingly with opt-out preference signals, the global privacy control approach, where consumers, and extending that now through the Delete Act in California and several other states coming up for data brokers. I mean, really opting out and having that refreshed every 45 days for data brokers. So there is an extensive, well-considered, debated, thoughtful legislative framework for governing ad tech, and wiretap legislation passed in 1967 is not it, nor is it holding hostage companies. I know you don't want me to talk about that, but it is. I do think that it detracts from energy companies can put towards really fortifying their data governance programs and building that out, because they're just running away from these incessant demand letters, sometimes getting them from the same firm again and again. So
do we have hopes? The California legislative process, I was a New York State legislator, and so kind of know what goes on there. And, Keir and our state team are obviously on top and tracking, but the California process is, got some nuance. So we've got a proposed bill in the Senate, which passed through committee and is now heading to the full Senate. Should we be optimistic that there's something going to happen here? What's the flow?
Yeah, well, it's not yet in front of the full Senate. So the Senate Bill 690, for those of you who are tracking, was introduced by State Senator Caballero, and it was assigned to the Public Safety Committee because the weird thing about SIPA is that it's a criminal statute, and the Public Safety Committee in the Senate they get all those bills. Normally, a privacy bill in the Senate is sent to the Senate Judiciary Committee, where there are staff members who have a lot of history, a lot of institutional memory and knowledge about privacy. That didn't happen here. It went to this Public Safety Committee where they wrote up something about the bill, which was very it wasn't what you would probably see out of the Judiciary Committee. But in any event, it passed out of that committee. Somebody marked the bill, well, not somebody, the legislative office marked the bill as having a fiscal impact, which for the life of me, I can't understand why. But all manner of bills are marked with a fiscal impact. Even the opt-out preference signal bill that's moving through, that was marked as having a fiscal impact. So what does that mean? It means it goes to the Appropriations Committee. And the Appropriations Committee is they get all the bills with any fiscal impact. And then what they do is they effectively call out a lot of bills. A lot of bills die in the Appropriations Committee. And that is a risk here in the Senate side. If they make it through, well, I'll tell you, I can slow down. What happens is bills that will have an impact over a certain monetary threshold are put on what's called suspense file, where they kind of disappear. And in 3 weeks, all the backroom negotiating will go on, and we'll know in one day if it moves ahead or it doesn't. So that's one path.
Wow. So may I suspect the worst? Why a bill would have fiscal impact to the state when it clearly has nothing to do. People maybe no longer having to put up opt-in banners and better complying with the current law, but maybe somebody flagged it specifically so that approps could then squish it and squash it.
Yeah. So so in the Senate side, I have hope because the woman who sponsored the bill just happens to be the chair of the Appropriations Committee. So that's good. But when it then assume that it moves out of appropriations and then it would go to the floor of the Senate. If it passes, then it goes over to the Assembly and goes through the same process. The issue there that I'm not so excited about is Buffy Wicks is the chair of the Appropriations Committee on the Assembly side. And if you remember, Buffy Wicks is very, very anti-business. She sponsored a bill that wanted a private right of action added to CCPA back in 2019. So it's possible that it won't make it out there. And, so
there's no House version of it where it might or might not be marked as having financial impact. It's the Senate bill that's going to go over.
The Senate, but it can be amended. And in fact, I didn't indicate in the Public Safety Committee, it did pass, but there was pushback from Scott Wiener, who's very active, and another senator about the retroactivity clause. So what the bill does at a very high level is it carves out commercial business purposes, which is defined as business purposes under CCPA, and also anything for which you would have an opt-out right under CCPA. So that's one thing. And then it says it's retroactive such that it applies to any case pending as of January 1 next year. And there are lots of cases pending. So people didn't like the retroactivity provision, and they didn't like the fact that it wouldn't apply to big tech, that it would somehow, they characterized it as letting big tech off the hook. So in any event, it passed that committee. It's gone into the black hole of appropriations, and May 23rd will be the date that they have to, either pass it along to the floor or put it in the suspense file. And I don't know the basis on which they would do that, but anything's possible.
All right, don't celebrate yet.
Yeah, I don't think so. But you know, it's such a mixed bag, because if you look at who supported this, the agency hasn't supported it. In their last board meeting, they had a legislative update where they updated the board on all the privacy laws that impacted their work. And this was conspicuously absent, even though it really does. This is ad tech. This is what they're regulating. They covered other bills that, you know, that were automated decision making. This is what we're regulating. Workplace surveillance. This is what we're regulating, but not this. Alistair McTaggart asked about it, and Maureen Mahoney, who's the legislative director, said, we'll talk about it later. So that's a mixed message. We don't see the ACLU of California supporting it yet. We don't see Consumer Reports supporting it.
But not opposing.
Not opposing,
right?
But quiet. Meanwhile, they're actively supporting the opt-out preference bill. They're actively supporting the location privacy bill. So it's not like they haven't made decisions yet about which bills they're supporting.
Yeah, I wouldn't expect them to support the bill, frankly. You know, much of civil society is funded by CPRA settlements and so forth. And, you know, it's a consumer right, blah, 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 like whatever. It doesn't make sense logically, but not opposing it and actually supporting the proper privacy regulatory path, I'll take that. That's a, you know, rational place to go. Well, it sounds like we need to have a summer intern look at everybody's campaign sites and then put up a list of which California legislators are wiretapping their constituents. It never matters because
that's the way to do it.
I do enjoy calling out the people who are the huge ed tech critics who are tracking and targeting and doing all the things, you know, and are exempt to some degree because of they're not a commercial enterprise or the like. But that doesn't ever seem to make any difference. People are comfortable talking about these technologies as being, you know, egregious and horrific as they use them to get their message out. But maybe if we say, hey, you voted that this is wiretapping, right? You specifically wouldn't, you know, didn't vote, would have voted. And so you're wiretapping. If you're not, then you ought to be, I don't know. We'll see if it makes a difference.
Yeah. I mean, the frustrating thing, yeah. I mean, the really frustrating thing for my clients is that it's the tools that where people are acting as service providers are processing, that even those are in scope. And that's just crazy making. You know, we have opt out of sale, people get that, but extending it to all non-essential cookies is just, it's crippling. It's really annoying. So.
Hey, you mentioned the agency. So it does seem there's a vibe that's a bit different the past few months. The agency, since its inception, you know, certainly was ratcheting up the maximum interpretations of its authority, doing, I didn't know they were an AI rulemaking agency, and they are somehow, right? Because the language opened the door to that, and very often, you know, comments filed, the positions were expansive, and it does seem that in recent times, even McTaggart, you know, who obviously was the champion, you know, was speaking up for practical terms, pushing back, you know, at some of the agency proposals. The governor now, right, sending letters. Is this just part of the new vibe because of the exuberance for AI and maybe some sense that California has gotten way ahead of a lot of other jurisdictions in its sort of regulatory activity, and we ought not to break AI? Or is the new director, who was, I recall, one of the big champions of the initial ballot initiative, I think was one of the funders or co-chairs or some core part of the McTaggart and crew team, and then, you know, has gone on to do lots of advocacy around delete acts and that sort of thing. So what difference? I mean, Ashcan, you know, we all know for many years, and obviously saw his work at the agency. He came to it with a very specific, you know, technologist, cookies and tracking, and, you know, a long history. How do we think the new director is going to shape things a bit differently? He's a bit more of a business entrepreneur, obviously with a bit, a significant privacy bent. But what's your perspective on the current vibe around the agency and its future activity?
Yeah, I think a lot of that, what looks to be a big business push, is about AI. I think it's about AI in a couple respects. I think first, Governor Newsom, is concerned, has voiced concerned about overregulation. But there have been many letters sent by legislators ceding the record, in my opinion, for future litigation to say that the agency had been really way over its skis in the initial draft of these regs. And if you look at several of the bills now on the docket, they're trying to make a name for themselves and do just that through the legislative process. And I mean, there is an argument that the legislative process might be a more proper venue for some of this AI regs that really do feel like they've gone way beyond the 3 or 4 sentences in the CCPA authorizing them to draft regs about certain, ADM, automated decision-making technologies. But at the same time, they're beefing up enforcement. At the same time, they are actively investigating. So I don't think they're pulling back from their mission. I do think, but having said that, I do think that they're cognizant of the litigation risk and the time and energy that will be spent fighting their more ambitious proposed regs. And I think pulled those back. I mean, I'm just speculating. I don't have any firsthand knowledge, but I would think that was a motivating concern expressed by people on the board as well, like Alistair.
Yeah, and I think we should be cognizant around on the enforcement side. They haven't pushed the envelope like the cases, you might debate, certain things, but they've generally been focused on the parts of the rule and parts of the law that are fairly well established, whether they, got what was happening in a particular case, right or not. I do think that some may look at the number of cases and enforcements and say, well, is a lot going on there. And I've been cautioning people because like who've got clients and hear about clients and hear about what's happening at the agency, there are a lot of cases underway. To their credit, they don't make these public until and unless maybe the company discloses it, or because it feels it needs to, or because there's a settlement or or an enforcement decision. So they can't talk about it, but certainly from staff there and from what we hear from companies and so forth, there are a fair number of cases which we will eventually, unless they drop some of them, we will eventually hear of settlements or conclusions. I think there are a fair number of companies sort of pushing back because this is all new. But to anyone listening and watching, thinking like, well, the vibe's a little different. Okay, so maybe the new rulemaking process or expansive interpretations may be softened, but the basics of registering and deletion and all the clear rights, if you're not on top of, and I think we just saw that with a recent action, right?
Today, yeah, they announced it, or maybe it was last night. A data broker action, but we had another enforcement action. I don't know if this week is zoomed by. Was it earlier this week or last week? I think it was earlier this week.
The clothing,
Todd Snyder, the retail suit company. They announced that enforcement action. But I agree, they are kind of staying in this lane. They are telegraphing what we're concerned about through their enforcement advisories, and then they are acting on it. And at the same time, like you said, there are a lot of active investigations. I am, helped found and I'm very involved with the California Lawyers Association privacy section. We put on a conference every year, and we had regulators at the conference just in February, and the question was asked, how many active investigations do you have? And both the AG and the privacy agency said they had well over 50. And don't forget, this is going on in other states. Texas kept he kept his hand up. 50? Do I hear 100? It was still up. I mean, they, as you know, I know we're talking California, but they've really beefed up their privacy office in Texas and is very active. So it's not just, and they're all sharing information. I mean, they announced that formally a couple of weeks ago, but we've known that's been going on for a very long time. And not just the investigations, they're getting complaints. Their latest report said they had almost 3,800 complaints in less than 2 years. That's a lot. And they look into each. And then they love their technologists that Ashkan was, so proud of incorporating into the agency, rightly so. But they're snooping around. So you have these different tiers. You have the public announcements, which are few and far between. You have a fair number of active investigations. And then you have people poking around and following up on complaints and looking into things. So there's really nowhere to hide. I think it really requires, a robust and building out your data governance program. Is what we're telling our clients.
I will never forget being on stage last year during the California Lawyers Conference, and a wonderful event for those of you who haven't been. It's really worthwhile. It's a great conference and really gets deep, obviously, into all nuances of everything happening in California, with good participation from agencies and from the AG and from lots of the litigators, and super useful. I was surprised. It was my first time. I guess it's not that long that the event's been held. But
no, we've had our third year this year.
I heard this year was great as well. The big value, I thought, when I was there. Well, so I'll never forget being on stage for like an armchair keynote, and everyone's like looking at me suddenly, and I'm like, what? I mean, okay, what did I say? And then no, they're not looking at me. They're looking, and I realized the whole like TV thing behind me was swinging, and there was an earthquake. I didn't realize because I was just blabbing, but small, but not immaterial earthquake right while I was on stage. So anyway, that was.
And I think it coincided with the agency prevailing on its appeal.
Right. That was the other earthquake on the challenges to the applicable the law. But the vibe, again, I'm maybe saying vibe too much today, but it was really interesting to get the flavor firsthand from the AG staff and from the agency staff, about how they were thinking of things and how they were driving things. Any other flavor from the participation of a lot of those local California enforcers or litigators that is worth mentioning?
Yeah, I mean, I think it's nothing we don't know, but it's worth repeating. Is minors online, like kids data, teen data, location privacy. You see it reflected in all the bills right now. And the nice thing about our conference is, frankly, we've attracted regulators from around the country. So while it is the California Lawyers Association, what was really enriching was to just see the ever widening landscape of privacy enforcement, and how, it's as each state passes a law, they beef up their staff, and it's one more surface, of enforcement. It always strikes me how, first of all, the privacy community is very tight, but it strikes me how close these regulators are. You can tell that they know each other well. From other states, I mean, not just the agency and the AG here in California. They like each other, they know each other well, they're comfortable talking to each other, and they obviously have relationships. So that just underscores to me all the information sharing, all the borrowing regs, all from one another, and looking to new amendments, which you see. I know Keir covers that at length. I won't go into that, but there is a fair degree of similarity.
Yeah, we've been putting together networks around the world, not only state legislators, data protection authorities. because we have found that most of those folks don't actually know each other, don't have regular cooperation with each other. They've got to sign formal agreements when they work together. And so, yes, the European folks all are cooperating via the EDPB, but Singapore and Korea and Brazil and this sort of thing, maybe the commissioners, meet at conferences, but the mid-tier staff who are really doing a lot of the heavy work don't always get to go fly around to the fancy places, and they're globally disparate. And even state legislators, they don't regularly go to other things in other states. Maybe they go to the National Conference of State Legislators, and they don't collaborate. And so they want to, but in many cases, we've had to create sort of just groups, meetings, calls. But the state enforcers have no such problem. There are not that many of them. They do collaborate. They sign on. They're co-counsel, right? They bring group things. Their bosses are close political allies. So very, very different dynamic. Our friend Claire Lucy Redhead, longtime privacy counsel, says, what is the name of the California conference? So this is the California Lawyers Association Privacy Section.
Privacy, I think it's the Privacy Summit. But if you just go to the California Lawyers Association, which is essentially the state bar for all the groups that were once under the state bar, like the litigation section, we started a privacy section 4 years ago, and it's exploded. So you can imagine. But anyway, that's where you would look for it.
Mm-hmm. And that's the annual summit, and you guys.
Yeah, it's usually, I think we're planning on February or March. We have a small conference. We're actually planning in Berkeley for October. So you'll see that on our page as well. Oh. I should have said at the outset that everything I'm saying, I'm not saying on behalf of Sidley. It's my own personal opinions. So
please don't conflict with the FPF Senior Executive Members Retreat, which is also in October in Berkeley.
No. Well, we'll have to coordinate.
Or that would make it convenient for some people to go to both. That might be very cool.
I mean, one other thing I just want to say as a takeaway from the conference was the absolute impatience that Stacy Chesser communicated with companies that don't have functional opt-outs and an auditing process. And I mean, she was just like, there's no reason, it felt like I was in front of my mother. I felt like I was, 11 years old again. So there's really no patience.
And you're sitting up there because they can see that, right? There's ugly things that happen.
They play with it. They know it. It's visible to everybody. And they're going to ask you for, this is harder, but, the other point being that, that privacy needs money thrown at it. That we want companies to realize, just like cyber, privacy is a thing, and you have to invest resources. And I think that's what's, they have all these vendor compliance programs where they really want you to produce a list of every single vendor, every single tracking company, and your contractual provisions to have that all tied up. That is a heavy, heavy lift for a lot of companies. And I think they're signaling this is the expectation. So plan for it.
Well, lot to chew on. I'll close with recalling that at the California event, Stacy, during her remarks, people asked, well, where do you decide, where to go in terms of complaints? And, in addition to the complaints that they get, she's like, we're consumers. She's like, my mother calls me. I'm on the web. We do stuff. And these are things that we can easily see. Our friends call us and say, well, I just did the... people who are in for the IAPP conference last week, some of them parked at a garage. And then there was all this chatter about how they were surprised that instead of, putting in a credit card, they put in their phone number and then it recognized them on the way out. And they were all like, wait a second, there's license plate scanners. And so all of us were looking up, who is this company doing this stuff? And of course they monetize the data. Who knew that when you parked, you were now part of a data brokering monetization, and somebody is selling information about the kinds of people that are shopping or attending that area, right? So right. They are there. And so
it's funny. I do tell my clients if they're in a certain, because I know these the people, obviously, the regulators. You're in their demographic. They have a teenage daughter. They are buying diapers, whatever it is. So.
Exactly. Good. Well, Sheri, thank you so much for joining me on this Friday. Thanks to all of you who listened in. We'll keep an eye on the comments if anybody posts any follow-up questions. See some of you perhaps at the next California Lawyers Association privacy event. And Sheri, thanks for sharing your wisdom. Hope you all, if you didn't already know her, got to see what a deep and amazing counsel she is. So happy Friday, all.
Thank you. Happy Friday. Thanks, Jules. Bye.